If you're a military family in North Carolina right now, if you've received deployment orders, if your spouse is heading overseas, if you're dealing with a custody situation that just got a lot more urgent, then this video is for you.
The U.S.-Israel military operation against Iran that launched February 28th has changed the readiness posture at bases across the state. Camp Lejeune, Fort Liberty, Seymour Johnson.
And we are seeing that play out in real time in our family law cases. I'm Granger Benson.
I'm Wes Taynton. I'm an attorney at Cape Fear Family Law in Wilmington, North Carolina.
We are a military community of attorneys, and this is our backyard. We know these cases. Now let's talk about what you need to know.
The most important law for any deploying service member to know is the Service Members Civil Relief Act, the SCRA. The SCRA is a federal law that provides legal protections to active duty service members when military service materially affects their ability to participate in civil legal proceedings.
In plain English, if you're deployed pursuant to military orders and you can't show up to a divorce or custody hearing, the SCRA can pause or what we call stay those proceedings. And here's what that means practically. If your spouse files for divorce or custody modification while you're deployed and you generally cannot respond because of your military duties, the SCRA gives you the ability to request a minimum 90-day stay of those proceedings. In this area, our courts can and often do grant longer stays than even the minimum of 90 days. However, and this is critical, the SCRA stay of proceedings is not automatic. You or your attorney have to invoke it. You have to request the stay from the court. Courts will not just put a pause on everything the moment that someone is deployed. The second thing to keep in mind is that the SCRA also protects against default judgments. If a court enters a judgment by default against you because you didn't respond to a lawsuit and your failure to respond was due to military service, you can often have that judgment set aside. Know your rights and invoke them.
Let's talk about what happens to your kids when you deploy. If you have a custody order in place, the first question is, does it have a deployment clause? If it doesn't, and many orders don't, especially older ones, you may be operating in a legal gray area. A deployment clause in a custody order should address 4 things at minimum. 1, temporary transfer of custody. While you're deployed, does physical custody shift to the other parent, a family member, or remain shared in some modified form?
Number 2, contact and visitation while deployed. What is your right to call, video chat, or otherwise maintain a relationship with your child, and what's the frequency for your ability to actually contact your child?
3, delegation of custody to family members. North Carolina law actually allows a deployed service member to delegate their custodial time to a family member, like a grandparent, during deployment. This is powerful protection many people don't know about.
And number 4, reversion upon return. When you come home, custody reverts. Well, what's the timeline for that? Is there a transition period? If your current order doesn't address these things, you need to get it modified before deployment, not after. Courts in North Carolina are generally very willing to accommodate military families on expedited timelines when deployment is imminent.
North Carolina law specifically recognizes electronic visitation. FaceTime, Zoom, Skype, whatever platform you use, as a valid form of parenting time. Your custody order should specify a regular schedule for electronic visitation during deployment. When, how often, on which platform, who initiates the calls.
Because when there's no specificity, you get disputes. And disputes during deployment, when you're already halfway around the world and operating under military constraints, are incredibly stressful, not just for you, but also for your family and your child. You want to get it in writing, get it specific, and get it in place before you leave.
Military retirement is one of the most significant assets in a military divorce, and it is governed by a specific federal law, the Uniformed Services Former Spouses Protection Act, or USFSPA. Under the USFSPA, military retirement pay can be divided as marital property in a divorce. The amount and method of division is determined by state law and your separation agreement or court order. Direct payment from the Defense Financing and Accounting Services,
or DFAS as we know them, to a former spouse is available when the marriage and the military service overlapped for at least 10 years. This is known as the 10-10 rule. And what's important to know is that the 10-10 rule doesn't affect whether a former spouse is entitled to a share. It only affects whether DFAS will divide the pension on their level and send the money directly to the other party each month. Our courts can and usually will still award a share of the retirement pension even in shorter marriages.
Military retirement division is technical. It requires a specific court order called a military retired pay division order. Do not try to handle this without an attorney who knows what they're doing.
Finally, let's talk about money, specifically BAH, which we all know is the basic allowance for housing. BAH is a non-taxable military pay component that helps service members afford housing. In North Carolina, BAH is considered income for the purposes of calculating child support and alimony. This matters because when a service member deploys and their BAH rate changes based on duty station, and it often does, it can affect child support and spousal support calculations. Deployed service members also sometimes receive additional combat-related pay that is also considered income in North Carolina for the purposes of those calculations. So before you deploy, you want to get the full picture of what counts before your support obligations are set.
Military families sacrifice more than most people will ever fully understand. The least we can do as family law attorneys is make sure that your legal rights are protected with the same level of care and precision that you bring to your service.
Cape Fear Family Law serves military families throughout Wilmington, Jacksonville, and across eastern North Carolina. If you are a military family dealing with any of these issues, custody, deployment, divorce, or support, reach out.
The consultation link is in the description. We will take care of you. I'm Wes Taynton from Cape Fear Family Law.
I'm Granger Benson from Cape Fear Family Law, and thank you for watching today.
And thank you for your service.